Good morning KCGC viewers, I am Hema Singh, Assistant Professor from Khalsa College of Law, Amritsar. My today's topic for the presentation is Need to Introduce Uniform Sentencing Policy in India. Before the commencement of the topic, let us understand the term crime, its elements and what is the difference between sentence and the punishment. The crime denotes any unlawful act which is prohibited and punishable by the state. Crime has been defined as an immoral and antisocial behavior which is contrary to the norms, beliefs, customs and traditions of the society. According to Hall Jerome, crime has been defined as legally forbidden and intentional act which has legally prescribed punishment for it. To constitute the criminal liability of the accused person, crime has been broken down into four main elements which the prosecution must prove beyond the reasonable doubt. The four main elements of the crime are human being, mens rea, actus reus and injury to another human being. The first and foremost element of the crime is that the injury must be caused by the human being. The second important element of the crime is that the presence of mens rea. The mens rea means the guilty intention or the guilty mind of a person to commit a crime. The mens rea includes intention, recklessness, negligence and the knowledge. The third important element of the crime is the actus reus. Actus reus is a Latin phrase for the guilty act. Mere presence of human being and the mens rea are not sufficient to constitute the criminal liability of the accused person because we cannot know the real intention of the person. For the actus reus element to be present, a voluntarily physical act must have been made by the defendant. The prosecution must prove beyond the reasonable doubt that the defendant has made a conscious and a voluntary act. The last element of a crime is that the injury must be caused to another human being or to the body of individuals or the society at the large. It is the duty of the state to make the laws for the protection of the rights and liberties of the individuals, and whosoever disobey these laws shall be liable to be punished. The quantum of punishment in India is generally decided by the substantive laws, depending upon the nature and the gravity of the offence. The object of the punishment is to prevent the society and is to prevent the crime and to protect the society and also to reform and rehabilitate the offenders. Section 53 to section 75 of the Indian Penal Codes incorporates the general provisions relating to the punishments for the various offences that has been prescribed under the code. Section 53 deals with the kinds of punishments. There are 5 kinds of punishments that have been incorporated under the Indian Penal Code, namely death sentence, imprisonment for life, imprisonment of imprisonment of two descriptions, either rigorous or simple, forfeiture of property and fine. Sentences are the statements in the judgments which lays down what punishment for a particular offence will be according to the law. And when the same is put into the action, it would be called as punishments. Thus, we can say that sentences are the predecessors to the actual infliction of the punishment. Sentencing is that phase of criminal justice system where the real punishment is pronounced after the stage of conviction to the convicted person by the judges. It is one of the difficult tasks that a judge may be facing while pronouncing it, as he has to consider number of relevant factors such as determining what actions or omissions are permissible, who is to be punished, with what kind of punishment is to be inflicted on the accused person, as to what extent the punishment is required, the availability of the evidences, the nature and the gravity of the offence, the nature of injury caused to the victim, the age and the health conditions of the accused person, motive and previous enmity and all other relevant factors. All these relevant factors invariably influence the choice of punishment. Sentencing requires the consideration of both aggravating as well as mitigating factors. Aggravating factors increases the seriousness of the offence and the culpability of the offender, and whereas the mitigating factors reduces the seriousness of the offense and the culpability of the offender. The law allows the courts to reduce the sentence if the accused pleads guilty. In India, judges have wide discretionary powers. Each judge exercises its discretion accordingly to its own judgment while pronouncing it. The main part of the judicial discretion is present under Section 360 of Criminal Procedure Code 1973. This section states that the judge have a power to release the offender on probation of good conduct or after admonition. But this power is subject to two limitations. Number one, where the convicted person is above 21 years of age and is punished with fine only or with imprisonment for a term of 7 years or less. Number two, where the convict is under 21 years of age or where the convict is a woman prisoner and is not punished with death or imprisonment for life and no previous conviction has been proved against them. Section 361 of CRPC states that wherein court could have dealt with the accused person under Section 360 of CRPC or under any provision of Probation of Offenders Act or under any other law for the time being in force but have not done so, the court shall state its special reasons for not having done so in its judgment. The entire debate of judicial discretion surrounds over disparity, discrimination and inconsistency of the sentence. Sentencing disparity occurs when two similar offenders are dissimilarly punished or when two dissimilar offenders are similarly punished. Sentencing disparity occurs when two similar offenders are dissimilarly punished or where two dissimilar offenders are similarly punished. So on the other hand, sentencing discrimination occurs when irrelevant criteria such as race, caste, social status are taken into consideration while awarding the sentence. On the other hand, inconsistency in sentencing occurs when the judge makes choice as to a particular approach in selecting the sentence. For instance, one judge may think that a particular offender should receive short sentence on the grounds of rehabilitation and whereas other judge may decide that the same offender should receive lengthy sentence on the ground of deterrence. This eventually leads to the unequal treatment of offenders under the criminal justice system. This unstructured discretion of the judges while pronouncing the sentence has resulted in disparity, discrimination and inconsistency in the sentence. In India, there is no guidance to the judges in selecting the most appropriate sentence. Currently, India has no structured sentencing guidelines. Neither the legislature nor the judiciary have issued any structured sentencing guidelines. Various law commission reports and the commissions have observed that there is a need to introduce uniform sentencing guidelines so as to minimize the uncertainty in the matter of awarding the sentence. In October 2010, the then law minister have stated that India is planning to introduce new structured sentencing guidelines in line with United States of America and United Kingdom sentencing guidelines. Despite all these recommendations and the plannings, no efforts has been made for its creation. So, in India, there is a dire need to introduce uniform sentencing policy to promote the fairness and to reduce disparity in the criminal justice system. Thank you.